If you're over 60, there's something crucial you need to do right now, because waiting too long could put your family, your assets, and your future at risk. I'm John Farrell, an estate planning attorney in Georgia, and today I'm going to walk you through the must-do steps for protecting yourself and your loved ones. Now, I know estate planning isn't the most exciting topic, but it's one of the most important. And trust me, I've seen what happens when people put this off. Families stuck in legal battles, assets frozen for years, and loved ones forced to make impossible decisions. But here's the good news. With a few key steps, you can avoid all of that and gain peace of mind. There are some easy and obvious ones in here, but there are also a couple that you might not have heard of before, so make sure you listen to all of them. And stick around to the end because I'm going to share the number one mistake I see people over 60 make when it comes to estate planning. Step 1. Let's start with the basics, your will. This is the foundation of any estate plan. If you don't have one, you're leaving your estate in the hands of state law, and that's never a good thing. Your assets might not go where you want them to, and your family could be stuck in court for months or even years. Now, if you already have a will, that's great, but when was the last time you updated it? Have you had any major life changes like a new grandchild? Have you moved to a new state? Have you changed your mind about who should inherit what? I had a client who thought everything was set, but when we reviewed her will, we found out her ex-husband was still listed as a beneficiary. She had completely forgotten to update it after their divorce. Imagine if we hadn't caught that. So take 5 minutes today and check your will. If it's outdated, make a plan to update it. Step 2, let's talk about one of the most critical documents, your power of attorney. If you become incapacitated due to an illness, accident, or even temporary hospitalization, who's going to manage your finances, pay your bills, and make important decisions for you? If you don't have a power of attorney, your loved ones will have to go through a probate process to get permission, and that can take months and cost thousands of dollars. I had a client, his name was John also, who never got around to setting up a power of attorney. When he had a stroke, his adult children couldn't access his accounts to pay his medical bills or even manage his home. They had to go to court, spend thousands on legal fees, and wait 4 months before they could step in. A power of attorney is a simple document, but it can save your family a world of trouble. And here's something most people don't realize. You need both a financial power of attorney and a medical power of attorney. The first covers your money, and the second covers your healthcare decisions. Step 3. Speaking of medical decisions, let's talk about your Advance Directive for healthcare. This is where you put in writing what medical treatments you do or don't want if you're unable to communicate. Do you want to be kept on life support? Who should make medical decisions on your behalf? I've seen families torn apart because one child thinks their parent would want every possible treatment, while another believes they would want to pass peacefully. This isn't just about you. It's about preventing family conflict in a crisis. Take 15 minutes to have this conversation with your loved ones and get this document in place. Step 4, review your beneficiary designations. One of the biggest estate planning mistakes I see is forgetting to update beneficiary designations, your life insurance, your retirement accounts, your annuities. These assets pass outside of your will, meaning whoever's listed as your beneficiary gets the money, no matter what your will says. So do yourself a favor, pull up your accounts today and double check your beneficiaries. Step 5, consider a trust for asset protection. If you own a home, have multiple properties, or want to avoid probate, a trust might be a smart move. It keeps your assets out of the court system. It ensures a smooth transition for your heirs. It can protect assets from lawsuits or creditors. I had a client with real estate in 3 states. Without a trust, his heirs would have had to go through probate in each state, costing them thousands. A simple trust saved them time, stress, and money. Before we wrap up, here's the number one mistake I see: waiting too long to do this. Estate planning isn't just for the elderly, it's for everyone. The sooner you get this done, the better protected you and your loved ones will be. Now, I know this can feel overwhelming, but you don't have to do it alone. My team and I specialize in estate planning and would love to help you put a solid plan in place. Click the link in the description to schedule a consultation, and let's make sure your future is secure. Thanks for watching, and don't forget to subscribe for even more estate planning tips.